Hi, this is Jen Rubin, editor-in-chief of the Contrarian. I have with us Andrew Weissman, one of our favorite contributors. Andrew, the Supreme Court issued a 5-4 opinion on Monday concerning the group of people who had been picked up and then deported to El Salvador without any due process, without any examination. What did the Supreme Court say, and what part do you think they got right, and what did they get wrong?
Okay, good to be here. So I'm going to start with just making sure people understand this is the case that Judge Boasberg has been dealing with, where there were two plane loads of people who were removed, as you noted, without a hearing, without due process. There is a process in place that the administration could have done that happens all the time, where they would say, here's our legal basis, here's our factual predication, and a judge would decide, is the, are the plaintiffs, the government right that they can be deported, and it would afford the people an opportunity to say that the government either got the law wrong or they got the facts wrong, meaning, you know what, I'm not in this gang. And, and the government would have to show that they are. They decided not to do that. And so there's been no process whatsoever. No court has been able to decide, did the government actually apply the Alien Enemies Act correctly? Is this a time of war? Is there invasion? Are these people who are removing, are they part of the group that is the invading force? So there are lots of legal and factual questions that were never allowed to be raised. And these people are now sitting in a prison in El Salvador. And that issue, the merits issue, went up to the Supreme Court because Judge Boasberg had said, this is going to be a temporarily restrained, this is going to be stopped, and also was looking at a separate issue about contempt. So the issue for the Supreme Court was sort of a very technical issue about, was this case properly before Judge Boasberg on a claim under what's called the Administrative Procedure Act, the APA. When you said this is a 5-4 decision, I really want to make sure people understand something, because I think there's been a lot of misreporting in my view. As Amy Coney Barrett signed on to, as the dissent said, as the per curiam, the sort of main decision said, as Justice Kavanaugh said in his concurrence, this was 9-0 on the issue that these people were entitled to due process before they were removed. They were entitled to have that hearing. As in a separate case, Judge Millett in the DC Circuit said, you know what? The government has accorded Nazis more process than these people. 9-0. To me, that is the key message here, that 9-0, the court has said, due process was violated. The issue that is 5-4 is the issue about the legal claim, the sort of the vehicle to get it into court. And that's where the majority said that it should have been brought under something called habeas. That's to say, release the body. You are holding this body, the body should be released. That's habeas, and not under the APA. And there was a healthy debate between the sort of per curiam on that and the dissenters on that issue. And it is a very gendered decision, because I actually agree with the dissent on the technical issue that you could have brought this under the APA, not under habeas. And the people who I agree with are the 4 women on the court. Amy Coney Barrett joined the so-called liberal bloc on that issue.
And once more, you see Amy Coney Barrett not necessarily going with the, if you will, the more reactionary, the more extreme justices. Now, what the majority in the 5-4 split said was, you picked the wrong court, and maybe, rather, you picked the wrong law, and maybe you picked the wrong court, and you have to go someplace else. And that other place would be Texas, which just so happens to be in the Fifth Circuit, which is arguably the most right-wing of all the circuits out there. Explain that part of the decision.
Sure. So what the court said, because you have 5 of the justices saying it has to be brought under habeas, and as I said, habeas is you, the government, are holding the body, and we, the person who's complaining, are saying release the body. You have to bring that claim where the person is being detained. And the court said that that is either in Texas, where there are a group of the class are now currently being detained, or, this is important, or wherever the person is. So we know some are in Texas, but if the person, let's say, is in New York, that would be the Second Circuit, and they could bring the case in New York. If they're in California, they could be in California. So it is true that there is venue for some of these people in Texas, but the court did not say that everything always has to be brought in Texas. And the final sort of our listeners who are sort of really attuned are probably going to be going, yeah, but Andrew, what about the people who are in El Salvador? They can't bring a case. There's no court system there's no US court system in El Salvador. And that is where those people have a very good argument that they can bring their case in, wait for it, DC as a habeas petition. And that habeas petition may end up back in DC before the chief judge in the district court, who is Judge Boasberg. So with respect to the people who are in El Salvador who have not had a hearing, who the Supreme Court has now said were entitled to a hearing. I mean, that's the key thing. There is now, all of these people have been determined by 9 justices. When have we ever seen that? 9 justices that they were entitled to due process. They may be able to bring their habeas before the same judge who is now steeped in the case.
Now, 2 questions. The first question is, what happens to the contempt issue? If you recall, our viewers recall, that the government seemed to have let the planes fly off after the order came to get those people back there. And Judge Boasberg was very concerned about the timing. The government wouldn't reveal the timing, saying it was covered by the Secrets Act. What happens to that issue now that the Supreme Court has corrected Boasberg, but sent it back to him?
So it is technically and thus legally still alive. When a court issues an order, you have to comply with it until you can get a court to say, you know what, I disagree with it and I'm vacating it. But you can't just be like, I'm going to ignore it and hope that it gets overturned. You have to comply. And the issue, so that means that even though the Supreme Court has said that the case was sort of improperly procedurally before Judge Boasberg, remember, just on a procedural matter, it needed to be brought as in a different way. That doesn't in any way say that his order should not have been complied with. So that is still pending before Judge Boasberg to make, and he is about whether the administration complied with his order. That is both going to require a factual finding and also a legal finding. He could ask for a hearing or more information on it, but that is something that he had oral argument, as you noted, Jen, last week, and he is going to presumably in the next few days make a decision about the next steps. But that is still very much alive in front of him. And so what I would say is educated guess is we should all be waiting for Judge Boasberg to rule on that. And I want to make sure people understand this is not a technicality. The government submitted a brief to Judge Boasberg saying, oh, this is picayune. This is a minor issue. This is not picayune. This is the constitutional crisis. This is the judge saying, did you deliberately disobey a court order? Was do not remove people, and if you have people on a plane, bring them back. And he's been vindicated in many ways by the Supreme Court, because the concern there was that these people had not been given due process. Well, you know what the Supreme Court just ruled? 9-0. that they were entitled to due process.
Right.
So that order that he issued is now very much vindicated by the Supreme Court. And this is not a small matter. It is a big matter. Now,
Yes.
obviously, we'll wait to see what Judge Boasberg finds. He may find, for the government that, legally they had an argument that this wasn't factually, that wasn't contempt. But, he obviously was very skeptical of that at the hearing. But until he rules, we don't know the answer to that.
Now, well, the government, I just suppose that they're going to make the argument that, oh no, you couldn't find us in contempt because we shouldn't have been there in the first place, even though we were, and you made this ruling and we may have violated, you can't do anything. This seems like a Trumpian kind of argument to make. Will that fly? And has that order, that potential contempt issue, gone up in appeal, or do they have to wait until Boasberg issues his decision?
So they should have to wait until he issues his decision. They could make that motion to Judge Boasberg. I think if I were the judge on that, I would reject it. I mean, that's just not the law. You can't take the law into your own hands. It does remind me of something that I do think is important if you want to have just a further sense of what the government's doing here. If you think it's bad enough that they have now been found to have violated the due process rights of all of these people. A statement was issued by the spokesperson for the Department of Homeland Security last night that basically said, you know what the story should be here? You know what the story should be here? The story should be that, like, these are bad people who've been taken off the streets. And that was said actually with respect to sort of Mr. Garcia, who has a separate case in Maryland. And I wanted people to understand just how lawless that is. We've already seen the cruelty that they could have done this through a process that accorded people their rights, and the Supreme Court has said that those rights were violated. But if you look at the lawlessness of it, what a spokesperson from our government is saying is, because the person's a bad person that we have unilaterally determined, they have no rights. They have no due process rights. If any president should understand that you actually have rights, even though you're accused of wrongdoing, you'd think it would be a president who faced 4 criminal cases. Under that rationale, you could just say, you know what, he didn't need a trial at all. He's guilty of all of the things he was accused of in New York and in Atlanta and in Florida and in Washington, and who needs a trial because he's a bad person. I mean, it's remarkable that that is a statement that would come from our government, that, you know what, just because we removed a bad person, that ends justify the means. And by the way, there's no evidence of that.
Yes, exactly. Right. That's the purpose of having a hearing and due process, because you don't know if these people are guilty, even if the law were applicable, which many of us think it is not. So the presumption that they're just going to divine guilt without due process is fairly symptomatic of this whole abominable cause of action. Now, I want to take a little step back and ask what it is the Chief Justice is up to. He was the one, after all, who came forward when Trump started talking about impeaching judges, most likely directed at Boasberg, and said, we shouldn't be having that kind of talk. If you don't like a decision, you take it up on appeal. And yet, rather than take the opportunity to get to the merits of this, which is really an individual hearing, he sided with the majority, prolonging this process, potentially sending hundreds of people to court in Texas, which is an unfavorable place, which he knows, on individual claims. Is he procedurally trying to undo whatever substantive right he thinks might be there? And more importantly, is he really kind of muddying his own message, which is this lawlessness has to stop and you have to respect courts?
I don't know the answer, but I do think that your finger is on the pulse of something important, which is that when you compare what the court has done in favor of Donald Trump's position, so when he sought an presidential immunity and the delaying of his criminal cases, they bent over backwards and delayed that so that justice was denied, and there was no day in court for him and for the public. And that took, as everyone remembers, months and months and months where that was allowed to happen. Here, you're seeing the courts act and the Supreme Court act with incredible alacrity when the government is saying, we need a quick answer, and they will act quickly. Now, to be fair, the key ruling here is against the Trump administration. So, it's not just no matter what you want, we give it to you. But by the same token, your point is there are people in El Salvador, human beings, who are just as entitled to that alacrity as Donald Trump was when he was a criminal defendant. They don't have an answer and have not been given their day in court to raise the issue about, was this legal? And factually, is it even applying to me? By the way, if it turns out it's legal and it factually applies to them, so be it. That's what the courts are for, but there has not been that process. So that somebody is there and there was a mistake made, and God knows any law enforcement agency, including ICE, the Immigration and Service, can make those kinds of mistakes. And I don't see the same equal treatment for these are human beings. And there was a point in the Sotomayor dissent that Amy Coney Barrett joined. So this is 4 justices, which was, and she pointedly said, if you do this again with even a single individual, a single person, you will have violated an order of the Supreme Court of the United States. And I just thought that showed such respect for a person, for the oath of office that judges are supposed to take to do equal justice under law.
Exactly. And as you point out, I think that does show that Amy Coney Barrett is cut from a slightly different cloth than the other justices on the right.
I totally agree with that. I mean, you may disagree with some of her decisions in terms of her philosophy. At times I've had questions about why she signed on to certain things, but she is showing it's not just an independence, but you do get the sense that she is an honest broker.
Yes.
Yes. And, that's my preliminary view, and you see it in a variety of decisions. And she also comes off with fundamental decency.
Yes. Last question. The Justice Department, the same Justice Department which has been firing people right and left, put on administrative leave one of the judges who is arguing in these cases, who said
one of the prosecutors.
With one of the prosecutors, exactly, not the judges, but the prosecutors, who said something along the lines that, yes, this was a mistake, or inferred there could have been a mistake. Off with his head, out he goes. Is that unusual? They said he didn't argue with enough vigor, that he wasn't properly defending the government, when in fact it was like he didn't know the answer. He couldn't make up an answer. What was your reaction to that?
So that's in the Garcia case, where the government has admitted that this was a mistake, that he was mistakenly removed. Jen, who litigates that? What government agrees that they mistakenly moved someone to a foreign country, that it was a mistake, and then says, we're going to litigate why we're not bringing him back? I mean, who does that? And by the way, I mean that in a completely bipartisan way. I've served under Republican and Democratic administrations at the Department of Justice. I can't imagine that conversation happening, regardless of sort of big P or little p politics.
Right.
The Court of Appeals addressed that very issue about the fact that this attorney was removed. And by the way, this is not some deep state, so-called deep state attorney. This is somebody who is a real loyalist and has argued all sorts of cases for the Trump administration. And was just appointed to his position with a lot of fanfare about how great he is by this administration. The court said, of course you have an obligation as a lawyer to zealously advocate for your client, but you are not a hired gun. You are first and foremost an officer of the court. And what does that mean? It means that you cannot lie. Surprise, surprise. And you have to be candid with the court. And that is what the Fourth Circuit said, that this person is removed for candidly answering about what they knew about the case, about the facts, and didn't make things up. I mean, and to your point about, does this happen? No, it doesn't happen. What we are seeing in Trump 2.0, we saw small versions of it happen in 1.0. And at that time, I remember thinking, this doesn't happen. People don't resign over this. People understand that there are policy differences, but you're not being asked to do things that are unethical or unlawful, or to obviously misrepresent something to a court. So it started to happen in Trump 1.0, but a real sign of the difference and the sort of ruthlessness and callousness of Trump 2.0, where we're seeing this kind of activity, and the courts, really pushing back in terms of calling this out. The Fourth Circuit called the behavior lawless, unconscionable. Those are incredibly strong words from coming from the judiciary.
And from the Fourth Circuit, which is not really known as some wide-eyed, right wing, that at least it used to be, was on the right side, meaning the more conservative side of the circuits. It might not be there anymore because they have some sense of decency and lawfulness. I think this entire episode, Andrew, has been so revealing in the most disturbing fashion about the people that we are dealing with, that would care not one whit about human beings, about the law, about truth, about respect for the judiciary. And I certainly hope that at least Chief Justice Roberts, who used to be an institutionalist, he kept saying he was an institutionalist, is taking note of what is going on. Because this is the point, as you put on, there is already a constitutional crisis, and it's going to get worse unless the Supreme Court puts a halt to it. It should be stopped now, but it won't be. And I think we are in for a terrible ride unless the Supreme Court really gets its act together.
I agree. I do think that, I just sort of want to go back to where we started, which is that you do have, on the key issue here, you do have a 9-0 decision. And what does that mean in terms of what we're likely to see? The attack on the Supreme Court is coming. So I know we're thinking the court has been so conservative, and it certainly has, and it has taken positions that you and I disagree with. But here, it tells you just how far the administration's gone, that they lost 9-0 here. And that means that the same kind of attack that, as we've seen on the lower courts, that we've seen on the media, basically on anyone who stands up to this administration, is now going to be that barrel is now going to be aimed at the Supreme Court. So, I would say, fasten your seatbelts, because we're going to be seeing the same kind of talk about impeaching them, about expanding the court, about removing jurisdiction from the court. There's no question that this administration can look to Bibi Netanyahu and what happened, the sort of outrageous things he did there with respect to his Supreme Court. I shouldn't say his, I should say the Supreme Court in Israel. But I think that's, what I'm looking at right now is thinking about what is now going to play out if the Supreme Court continues down the road of insisting that there be due process.
Yes. Andrew, thank you so much. It's always enlightening. It helps, I think, me to clarify exactly why I am so upset about this, and why so many other Americans are. So I'm sure, unfortunately, there will be other decisions that require your expertise. And as always, a pleasure having you, if not a pleasure living in Trump's America at this point.
Exactly. Well said.
So we will see you next time. Thanks so much.
Take care.